Welcome to the deep dive. Today we're getting into something pretty significant legally. It's a recent Supreme Court decision concerning the Trump administration and how they tried to use the Alien Enemies Act, specifically regarding some Venezuelan detainees.
That's right. It's a real intersection of, well, immigration law, national security questions, and, maybe most importantly, fundamental due process rights. And for this dive, we're drawing on a couple of things. A HuffPost News report, their take on it, and, crucially, the Supreme Court's own words in the actual opinion. That's the A.A.R.P versus Trump case.
Exactly. So our aim today, for you listening, is to really unpack this. Why did the Supreme Court jump in, especially with, a late-night decision? What's the core legal fight, and what could the fallout be? Basically, your quick way to get up to speed on a complex legal story without wading through all the jargon.
So let's set the scene a bit. The administration was looking to quickly remove these Venezuelan nationals. They identified them as members of Tren de Aragua TDA, which the government designated as a foreign terrorist organization. And the legal tool they reached for was the Alien Enemies Act. That's quite an old law, really meant for declared wars.
Oh, right. Not typically used like this. And that's where the case starts. A group of these detainees held at the Bluebonnet facility down in Texas. They went to court to try and block their removal. And, well, that's when things got interesting at the Supreme Court level.
Yeah, very interesting. The court stepping in late at night like that, issuing an order to halt the deportations. That's not an everyday occurrence. And, the HuffPost piece we looked at, it had a pretty strong interpretation of why the court did that.
It did. They basically read it as the court signaling it was, well, pretty fed up with the administration's tactics in these immigration cases. Strong language in that article. And maybe backing that up is the fact that this was an unsigned 8-page decision, a per curiam opinion. Only Justices Alito and Thomas dissented. That level of agreement from the rest of the court, it does suggest something significant.
Absolutely. And what seems to be at the heart of the court's immediate concern was this feeling that the government had, well, misrepresented the facts. They concluded the administration hadn't given an accurate picture of what was happening at Bluebonnet, specifically about the timing of the removals.
Okay, let's break that down. Misrepresented facts, how so?
Well, the court pointed to a specific moment. There was a district court hearing, April 18th, and in that hearing, the government lawyers apparently assured the judge that none of the potential class members would be removed that day.
An insurance given in court.
Right. But then the Supreme Court found evidence that suggested, well, actually steps were being taken to remove detainees that very afternoon.
Oh, wow. So a direct contradiction then.
It certainly looks that way. The Supreme Court opinion mentions detainees being taken from Bluebonnet to an airport and then later brought back. That sequence, the court felt, strongly suggested an intent to remove them, despite what was said in court earlier.
And this wasn't just about the timing, was it? There was also a big concern about where they were being sent.
Exactly. El Salvador. Specifically, a prison there called CECOT.
And CECOT has a reputation, doesn't it? Not exactly a place known for easy access to legal rights.
That's putting it mildly. The critical worry for the Supreme Court was this. If the detainees were sent there to this highly restricted facility, the U.S. government might then turn around and argue that no U.S. court could actually order them back or provide any relief, even if the removal was later found to be unlawful. It's sort of a jurisdictional black hole argument.
A legal point of no return. And they had a precedent for that worry, right? The Abrego-Garcia case.
Precisely. Kilmar Abrego-Garcia, someone previously wrongly deported, and the administration had apparently fought against allowing him to return. So the court saw a pattern. Potentially.
And the HuffPost article really hammered this point about CECOT.
It did. It stressed just how restrictive it is, highlighting that basically no detainee there gets a day in court, except for Abrego-Garcia managing to meet Senator Van Hollen. That's it. So sending people there without proper review first, that clearly troubled the court.
Which leads us straight into the due process arguments, the right to fair procedures. And the court really took issue with the notice period the administration was giving, didn't they? Just 24 hours?
Yes, a mere 24 hours. And the Supreme Court flatly rejected that as being enough. They connected it back to an earlier case, JGG v. Trump. That case established that detainees need adequate notice, so they actually have a chance to seek habeas relief, challenge their detention in court.
Otherwise, the right is meaningless if you don't have time to act on it.
Exactly. And the court's own language was pretty blunt. They said this 24-hour notice, which also lacked information on how to challenge the removal, it surely does not pass muster. Pretty clear signal there.
So, inadequate notice was a big piece. What else did the court focus on? There was something about class action lawsuits.
Ah, yes. Another tactic the court seemed unhappy with. It looked like the administration was trying to dodge a class action.
How so? By treating the individuals who actually sued differently.
Kind of. The argument seemed to be, look, we promise not to remove these specific people while their case is active, so they aren't under immediate threat like the others. And therefore, the argument goes, you can't lump everyone together in a class action because the named plaintiffs aren't representative anymore.
A way to pick off the leaders, essentially.
The Supreme Court saw right through that. They said, no, a defendant can't just defeat a potentially valid class action by selectively treating the named plaintiffs differently. That undermines the whole point of class actions, which is to address widespread issues efficiently.
And they also question the logic, right? How can people challenge the lack of notice if they haven't received notice in the first place?
It's a catch-22. The courts seemed very skeptical that the right to notice could only be enforced by individual lawsuits filed by people who, by definition, hadn't been given proper notice to file a lawsuit. It just doesn't track.
Okay, so stepping back, what did this Supreme Court decision actually do on the ground? What was the immediate effect?
Well, number one, it mandated real notice, something more than 24 hours, though they didn't specify exactly how long. Number two, it halted removals under the Alien Enemies Act within the Fifth Circuit. That's the federal court circuit covering Texas, and thus the Bluebonnet facility, at least until the lower courts rule further on the case.
So technically, the order only applied to the Fifth Circuit?
Technically, yes. But as the HuffPost analysis pointed out, the tone of the decision, this clear lack of trust in the administration's procedures, that likely sends a signal nationwide. It suggests other courts and the Supreme Court itself will be watching similar actions very closely everywhere.
But crucially, and this is really important for you to understand, the court didn't rule on the big underlying question. They didn't say whether using the Alien Enemies Act itself in this context was actually legal. The whole invasion or predatory incursion justification the administration was using, that's still undecided.
Absolutely, the critical point. Lower courts have actually split on that question. Is this situation what the 1798 Alien Enemies Act was intended for? Big open question. Justice Kavanaugh noted this in his concurrence. He agreed with pausing the removals to allow court review first, but he also basically said, hey, let's get these core legal questions about the act's applicability up to the Supreme Court and settled quickly.
So Kavanaugh wanted clarity sooner rather than later, but Alito and Thomas dissented entirely. What was their take?
Their main argument, led by Justice Alito, was jurisdictional. They felt the Supreme Court shouldn't have even taken the case at this stage. He argued the detainees hadn't met the high bar needed for the court to issue an injunction, that emergency stop order. And he felt the Supreme Court was short-circuiting the process by granting review before the lower appeals court had even ruled on the merits.
So too soon, basically, let the lower courts work it out first.
Pretty much. Alito also seemed to think the district court judge had acted reasonably based on the situation at the time. And he expressed doubts about the strength of the initial factual claims made by the detainees. He also questioned whether class actions are even the right vehicle for these kinds of habeas corpus challenges, and whether the specific requirements for class certification were actually met here. So, multiple layers of disagreement.
Okay, quite a lot to digest there. So let's try and boil it down. For you listening, what are the main things to take away from our dive into this?
I'd say first, the Supreme Court is definitely scrutinizing the administration's use of this particular law, the Alien Enemies Act, for immigration enforcement. They're watching closely. Second, due process is front and center. Adequate notice, a real chance to be heard in court before removal. These are clearly major concerns for the majority of the court right now.
Yeah, and it really throws that classic tension into sharp relief, doesn't it? The government wanting to act fast on perceived national security threats versus the fundamental rights of individuals, even non-citizens facing removal.
Definitely. And the third key takeaway is just remembering this isn't over. The really big question, can the Alien Enemies Act even be used like this today? That's still being fought out in the lower courts. This decision didn't settle that.
So, summing it all up, while the Supreme Court didn't decide the ultimate legality of using the act here, their intervention sends a potent message. It's a message about the absolute necessity of due process, even when the government is acting under emergency-type powers or citing national security. It signals potential limits.
And that leaves us with a really interesting thought for you to chew on. How do we strike that balance between a government's need, or perceived need, to act swiftly against threats, and the bedrock right everyone has to fair legal treatment? How could this ruling shape future immigration fights or the use of executive power in emergencies? What does it make you think about the court's role in checking executive actions?